So, ladies and gentlemen, each side is going to have 30 minutes to present their closing arguments to you. If anyone needs a break now, we can do a brief break for you now, or either both sides are going to proceed with their closing arguments. All right, state, you may proceed.
Here we go. So now we've got closing arguments from the state. Boy, who do you think is winning right now? Y'all let me know in the comments in the chat. This closing arguments from the state, I think, is going to be pretty straightforward and probably predictable. We'll see. Only 30 minutes.
In the world of Tamor McIntyre, Mark Anthony Saldivar was a nobody. Tamor McIntyre took Mark's life in that Chick-fil-A parking lot. He discarded him there like a piece of trash, and then when he got to El Potosino restaurant, he celebrated his slaying. Ladies and gentlemen, Mark Anthony Saldivar was a somebody. He was a good son, a brother, a friend, a photographer, and tragically, he was the victim of a capital murder committed by the hands of that defendant sitting right there.
Dang.
And we're going to talk about the law that supports that. Now, in your jury form, you have the lesser included offenses of manslaughter and murder. Now, manslaughter is if a defendant recklessly causes the death of an individual. Murder is when the defendant intentionally or knowingly causes the death of an individual, or the defendant intended to cause serious bodily injury and committed an act clearly dangerous to human life that causes the death of an individual. Now let's talk about the mental states. Intentionally is legally defined as a conscious objective or desire of the defendant. Knowingly means that the defendant was aware of the nature of his conduct and the circumstances that existed. Ladies and gentlemen, this is not a manslaughter case. The defendant did not act recklessly. An example of manslaughter would be somebody waving around a firearm and they believe the safety is on and it goes off and kills somebody. That's not what happened here. The elements of capital murder. The state has proved these elements to you beyond a reasonable doubt. You heard multiple witnesses testify that this offense occurred on April 23rd, 2017. It occurred in that Chick-fil-A parking lot in Bexar County, Texas. You heard testimony that the defendant, Tamor McIntyre, was the shooter and that he was committing a robbery when he took Mark Anthony Saldivar's life, intentionally, shooting Mark Anthony Saldivar with a firearm. Ladies and gentlemen, the law doesn't require you to be a mind reader. You can infer intent from words and circumstances and facts that surround the offense. So let's look at that. The defendant acted intentionally. He had his firearm displayed from that stoplight at McCullough. He had his firearm displayed the whole time to Chick-fil-A, and he opened his door, leaned half in and half out, and shot Mark Anthony Saldivar. Those are intentional acts. Now, regarding the robbery. Robbery starts at theft. Theft is the unlawful appropriation of another's property, and it is unlawful if you do not have the consent of the owner. What are the facts that prove theft here? You heard Lucy Saldivar testify that she gave her son Mark $10 before he went in that black Kia Forte. The physical evidence that supports the theft is Mark's wallet being at the Mexican restaurant. You see Jalen Bell putting on Mark's backpack at the Mexican restaurant, and Jalen Bell discarded Mark's phone there in the Chick-fil-A on their way out of the Chick-fil-A parking lot. Further, you heard Hester Rogers testify that the back passenger was yelling for help after being forced out of the vehicle. And Joanna Reyes testified that Tamor made the demand for Mark's backpack, Mark refused to give it up, and Tamor had possession of the backpack when Mark was forced out of the vehicle. And Joanna further testified that at the Mexican restaurant, Jalen Bell was mad because there was only $10 in the wallet. Now, how do we get to robbery? It is committing the theft while causing bodily injury to the victim to maintain control or retain control of the property. Ladies and gentlemen, you've heard multiple witnesses testify to that. And the photos from the ME, you saw the knot that Mark had on his forehead. You saw the contusions that he had near his nose and his mouth. That proves robbery. You heard multiple witnesses testify. Ashley Buenteo testified the front passenger used the handgun to strike the back passenger. Paul Caballero testified that the front passenger was fighting the back passenger. Hester Rogers testified that the front passenger was brandishing the firearm while fighting the back passenger, and Joanna Reyes testified that Tamor beat Mark and took possession of Mark's backpack. Now I want to talk to you about the law of parties. Our law provides that a person is criminally responsible as a party to the offense if it's committed by his own conduct or the conduct of another. Jalen Bell and the defendant fled San Antonio with Mark's belongings, and this defendant, even though we have proved that he is the shooter, should you choose to not believe that, he is still criminally responsible for what happened in that car and for the death of Mark Anthony Saldivar, because he was an active participant in the beating and taking of Mark Anthony Saldivar's property. Now, when you retire to the jury room, if you find the defendant guilty of the offense of capital murder, your deliberations stop there. If you do not find him guilty of capital murder, then you would proceed to the lesser included offenses of murder and manslaughter. There are possible defenses to murder and manslaughter, and we'll talk about those. They're in the jury charge. It's self-defense and defense of a third person. Now, just because these affirmative defenses were submitted to you does not mean that the court is indicating anything to you, or that it's just that the defendant is entitled to those affirmative defenses, and that's why they're in the charge. Now let's talk about self-defense. A person is justified in using force against another when and to the degree the person reasonably believes that the force is immediately necessary to protect himself against the other person's use or attempted use of unlawful force, okay? A reasonable belief is a belief that's held by an ordinary and prudent person. The use of force in this case was not justified for many reasons. One, Mark was not using unlawful force against the defendant. He was merely trying to obtain his belongings back. There's no evidence that Mark ever injured the defendant or even engaged with him in the physical fight.
Oh, objecting during closing. Wow.
Furthermore, the defendant provoked. If you do find that Mark did use some type of force against the defendant, that force was provoked by the defendant, okay? The defendant is the one who put all of these acts in motion. And the defendant never abandoned his robbery of Mark Anthony Saldivar. And I'll tell you what abandonment would have looked like. Defense is going to get up and argue, oh, the gun was just up in the air, oh, the gun was put away and then taken out again at the Chick-fil-A. No. What abandonment would have looked like in this case is giving Mark his things back and driving off. But that's not what happened. And you see that in the Chick-fil-A video. Now, talking about deadly force, it's pretty much, thank you, Judge. It's pretty much the same as what I just described, except the person that the defendant is acting against has to be using or attempting to use unlawful deadly force. Mark Anthony was not using any deadly force against the defendant. And the defendant does not get the presumption of reasonableness because he provoked Mark, and the defendant was engaged in criminal activity, and that is that robbery. A person is justified in protecting a third party if they believe, or if they would have been justified in using self-defense themselves, which we've already established that the defendant was not entitled to. And the use of deadly force was not justified in this case because Mark was not using deadly force against anyone in the car. They were all using deadly force against him.
That's what it sounds like.
Now, you all heard many witnesses in this case, and you're the exclusive judges of the facts proven, the credibility of the witnesses, and the weight to be given to the testimony. Now, I want to talk to you about the accomplice witness rule. Now, if you believe that Joanna's testimony naming the defendant as the shooter is true and shows the defendant guilty, you have to further believe that there is other evidence in the case to substantiate what her testimony was. And at that point, you can then find the defendant guilty. So let's talk about the other evidence in the case that tends to connect the defendant with the offense committed. The 911 calls, the lay witness testimony that you've heard. And defense is going to get up here and they're going to tell you, well, there were inconsistencies. Ladies and gentlemen, that's normal. There were multiple witnesses in this case, but they were not consistent about the important parts of this case. Who had the gun and who was in the front passenger. And they're going to argue, thank you, Judge, they're going to argue about the race. Some people said, oh, it was all Hispanics. I urge you to consider where the witnesses were. Elizabeth Adams did say she believed that the occupants of the black Kia Forte were Hispanic. She was standing in the DoubleTree parking lot. Everybody that was in the vicinity, Hester Rogers, who was standing right there on the curb, described him as a medium-skinned black male, and the occupants of the car, Ashley Buenteo and her uncle, described a black male as well. The Chick-fil-A video, the El Potosino video, the letter in the clothing and the trunk, the phone records, and the digital evidence all corroborate and tend to connect the defendant to this case and being the shooter in this case. The blue phone that was found in the front passenger glove compartment. Ladies and gentlemen, that digital evidence is telling you who is the owner of that phone. TK47 iPhone and TK47U at iCloud.com. That's the owner of that phone. Now, you have in State's Exhibit 141 phone records from Joanna Reyes's phone. And I want you to take a look at those, because what you will find is if you compare the phone records from Joanna to the call logs in the defendant's phone, which is State's Exhibit 140, you're going to see some overlap, which corroborates Joanna. That first phone number up there was last called in the defendant's phone on March 11th of 2017. The defendant had communication with that phone number 6 times. Beginning on April 23rd, 2017, Joanna's phone calls that number 20 times. The next number, the defendant had communication with that number at least 43 times, and the last call was on March 8th of 2017. Beginning on April 25th of 2017, you'll find that number 8 times in Joanna's phone records. And that last number, the defendant had over 80 interactions and last called on March 8th of 2017, and there's 14 calls from Joanna's phone beginning on April 20th of 2017. All of those things corroborate Joanna. Further, in that blue iPhone, there's a picture of the defendant wearing the slides that were in the car and are pictured in State's Exhibits number 126. Ladies and gentlemen, at this time, your sole duty is to determine guilt or innocence in this case. The state is not required to prove our case beyond all doubt, just beyond reasonable doubt, and we have proven our case to you.
What do y'all
You
think?
are not to let bias, prejudice, or sympathy play any part in your deliberations, and you have taken an oath to render a true verdict according to the law and the evidence in this case. Ladies and gentlemen, that verdict is finding the defendant guilty of capital murder. Thank you.
Wow, short, sweet, and to the point. Dang. They are not playing around. She said, listen, guys, you heard the testimonies. You saw the evidence. Get this dude up out of here. Oh, my goodness. Did somebody take the time? We should have marked the time to see how long that took. Let me know what y'all think about this in the comments in the chat.